Hello everybody. Today we're going to review significant course cases that affected special education. So we're going to start with Brown versus Board of Education. Now Brown versus Board of Ed is not originally intended to address issues with students with special needs. However, cursorily, Brown versus Board of Education is about civil rights and separate but is not equal, and those things there. So it has a direct relationship with special education. So this was back in 1954. You had the Civil Rights Law of 1965. You had the Elementary Secondary Education Act of 1965. And then you had, for special ed, specifically Section 504 was passed to reflect this issue, and it is an anti-discrimination law, actually 1973, and that it intends that all students with a handicapping condition that affects a major life activity can be served in school. And so that was the Brown versus Board of Education, kind of created those things along the way. So here we go. It was the 14th Amendment, originally protected African American children, and it's an anti-discrimination civil rights law. The next one is Diana versus State Board of Education, a 1970 law. And what happened, there were students in California that were of Hispanic origin, and they spoke Spanish, and California was using a single test to identify the student with a disability, and it was given in English, not in their native language. So there was a lawsuit filed and changed the way we do assessment today. And so that's really important. It corrected a bias in assessment procedures. It addressed students whose primary language was not English, and they must be tested in both their primary language or, if appropriate, then in English. So that's important. Then originally protected a Mexican American and Chinese American, that was Lau versus Nichols, did the same thing, and made proper testing procedures a thing. So we must use more than one test. We must use a culturally fair and culturally free test as much as possible, and in their native language if it's appropriate. Okay, the next one is Pennsylvania Association of Retarded Citizens, or for Retarded Citizens. Love that interchange there. And the Commonwealth of Pennsylvania, 1972 case. Pennsylvania was refusing to let students with intellectual disabilities come to school unless they met that 5th grade mental age standard, our 5-year-old mental age standard, which we know the mental age standard is arbitrary at best, not a very valid assessment, etc. And so this is a zero reject policy of idea, came from this right here. So PARC, it didn't go to the Supreme Court, and that was, they just agreed upon it. Ruled that schools may not exclude students with mental retardation from school. Ruled a free public education must be available for those students. Mills versus Board of Education for the District of Columbia. This is another case where, let me get my notes. It was 7 students sought rights for students not to be excluded from DC schools. And the school district basically said, we don't have the money to provide services for them, so you're out of luck. Well, when it went to the Supreme Court said you cannot use money as a way to keep students with disabilities out of school. So that was the big part. It established some principles later reflected in the Education for Handicap Act, access to free public education, due process protection, and rights to services, even if schools claim they don't have the money. Schools have to fund the money. The next lawsuit is Oberti versus the Board of Education of Clementon. And here, Raphael Oberti was a student with Down syndrome, and he was attending a half-day general ed and half-day special ed class. Oberti's parents wanted him to be in a non-segregated, full inclusion classroom. So out of this whole lawsuit is the LRE provision came, critical in establishing those inclusive practices. Schools must provide reasonable supports and services to students with disabilities in general education classrooms. Doe versus Withers. This is a very interesting case. Withers was a high school social studies teacher, and he was refusing to follow the accommodation plan of a student in his class. Withers was a very interesting guy. He was a state legislator in West Virginia, and so he kind of knew laws. But so he was just refusing, and his principal and his special ed director and his superintendent all told him to do it, and he said no, he wasn't. And the only real true accommodation that was needing to be done was oral testing. Because oral testing wasn't done, Doe failed his class and then was not allowed to participate in an extracurricular activity. Well, Withers had to go and do his state legislator gig, and they had brought in a sub to take his class while he was gone. The substitute provided the appropriate accommodations, and guess what? Doe was successful. So they had all this fodder to go forward. So the interesting thing, so it went to due process and went all the way to the court system. This is the first special ed court case that was heard in front of a jury rather than a hearing officer. It's also the first court case that money was given to the parents because Withers lost. Withers was held personally responsible for the failure of Doe, and he had to pay compensatory and other damages to the parents. He had to pay out of his pocket because he was actually found personally liable. So the takeaway from this is that if you are a teacher, follow either the IEP or the accommodation plan, whichever one it is. So there's the points that are really important. Okay, the next is Rowley versus Hedrick Hudson School District in 1982. And the Rowley case has been one discussed for a long time. Let me get my notes on Rowley. It's a case that went to the Supreme Court in 1982. It was a case where the young child the parents of the young child were requesting that a sign language interpreter be provided for their daughter. The daughter was an excellent lip reader and was being extremely successful in school, and when the sign language interpreter was there, she refused to use the sign language interpreter. So the school district finally said, we don't need to be providing that. The parents filed due process. The parents lost. The school district said that we have to just provide a education program that has meaningful benefit, and this is where that de minimis whole thing came out of, that we will later see in Endrew F. This is also where you heard the whole thing that The school district does not have to provide a Cadillac program, they just must provide a running Chevy program. So that was the standard for many, many years. And here's the information. It created the Rowley decision-making process, the two-part standard, that's now changed because of Endrew F. But we'll get to Endrew F in just a minute. This next one, Daniel R.R. This is a Texas El Paso case. And a student was being, parents wanted them also to be in a fully included kindergarten classroom. The student was behaviorally inappropriate, but the parents still won the lawsuit. And a whole huge standard of LRE and being able to be educated with non-handicapped peers, and those processes were all put into place by TEA, etc. And it's a LRE issue, so it's very interesting to talk about. The next, so there's this information. The Irving ISD versus Tatro. This is about providing clean intermittent catheterization for Tatro, and Amber would need to have that if she was to attend school. This case went to the Supreme Court, and it differentiated between the medical services and school health services. And clean intermittent catheterization ended up being identified as school health services. And so it doesn't require a physician for it to be performed. It can be performed by a nurse or a layperson, see right there in the notes. So that it was a big case there. Now, if you see the very last bullet, it said that it forbids a person by reason of a handicap to be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program receiving federal aid. Big deal. But a medical procedure is more like mapping for cochlear implants. That is a medical procedure, whereas clean intermittent catheterization or sectioning or something like that is not. Honing versus Doe is where a California school violated the Education of the Handicap Act. An idea when it suspended a child for behavior linked to his disability. So out of this came the whole manifestation determination process and other services and 10-day suspensions and all that stuff you see in the parents and student rights, procedural safeguard, under discipline, you see all that stuff under there. That came out of the Honing versus Doe lawsuit. And so finally, we come to the most current lawsuit, Endrew F. versus Douglas County Schools. And the student was receiving an education at a Colorado school. But what happened was the IEP team kept just readopting the goals and objectives of the student rather than creating new objectives and expecting the student to make progress. The parents pulled him out of school and put him in private school where he started making significant progress, and then they filed due process against the school district. School district lost, and as you can see, it went to the Supreme Court, an 8-0 decision. Big change. We no longer have the de minimis standard, but we have the standard that a meaningful education for a child, and it must be reasonably calculated to enable the child to make progress appropriate to his or her circumstances. So it changed the way we do things, and so now then you probably see that in your schools where you currently are. All right, I hope that helps you see these and see how we end up getting more and more There's lawsuits that will help inform what we do in special education to provide appropriate services to students with disabilities. All right, thank you very much.